Hello and good evening, everyone. My name is Roxanne Amihere, and I am from British Ghanaian Lawyers Union. We are collaborating with the British Nigerian Law Forum on Pathways to Law. By way of introduction, I would like to introduce everyone to BNLF again and BGLU. So we are an affiliation of lawyers. We are respected and an influential organization which is seeking to inspire, uplift, connect, and support our members. So our core focus is to promote Africans in the diaspora and within Africa in our careers as legal practitioners. We have built and will continue to enlarge our capacity, provide our members with the opportunity to develop and learn in collaboration with chambers, law firms, organizations, and companies. We have identified factors that hinder the career progress of our members, and we are assembling a board of respected advisors within our profession with a variety of skills to identify ways we can strategically operate to empower our members and break those barriers in our sphere of influence. So we are here as the British Ghanaian Lawyers Union in collaboration again with the British Nigerian Law Forum. We have Richard Williams from the SRA, and we have Dr. Victoria Stec from the SRA, as well as Libby Small. So this is the academic panel, which will be from 6 to 7 p.m. I would like to introduce you again to Mr. Williams, who will be talking about the pathway to law as a solicitor. So please feel welcome to begin with your presentation.
Okay. Thank you very much for the introduction, and thank you very much for inviting me and the SRA here to talk to you today. I'm going to now attempt that very challenging part of a presentation in trying to share my screen so you can get the slides that I'd like to run through. So if you just give me a few seconds, I'm hoping this goes very smoothly.
Perfect.
Okay, that looks like you've got my slides, I hope. Okay, yeah, I mean, I'm aware that we've got a kind of a mix of individuals in the audience this evening, those that might well be considering becoming a solicitor in the future, those that may already be on their pathway to becoming a solicitor, and those that may have qualified, and in particular those that may have qualified in an overseas jurisdiction. So I'm sure you're all aware, or hopefully you're all aware, of the introduction of the Solicitors Qualifying Examination. And that comes into effect from the 1st of September this year. So, really quick, really quickly. I think it's important then that and I hope you'll find it useful, that I try and sort of plot out what the SQE might mean for you if you're one of those, if you're an individual in one of those groups that I mentioned previously. So I'm happy for these slides to be circulated kind of after the meeting. So don't worry too much if there's something that you don't quite understand or want to pick up later. So I want to start really with at the beginning, and just to really outline what the SQE is, and to some extent why we're introducing it. You talked very much at the beginning, Roxanne, about your organisation's mission to increase kind of diversity and access in the profession, and actually that's at the heart of why we introduced the SQE. At the moment you have, from a regulatory perspective, very specific and prescriptive routes to qualification. There are certain stages and qualifications that you need to complete or meet, which does put in place barriers for some individuals wanting to become a solicitor. So that's kind of part of the reason why we introduced the SQE. The second is that actually, as a regulator, we need assurances that all solicitors being admitted to the profession meet the high standards that we and the public expect. So, I'm sure you're all aware, the current training contract route means that, you have many training principals in many different firms signing off individuals to very different kind of levels of competence. So that's the kind of rationale for introduction. The SQE, as you can see on the slide, it's a single assessment essentially. It's the assessment you take in order to demonstrate to us you are competent in order, you know, to become a solicitor. What that means is that single assessment is that actually everybody who wants to become or is admitted to become a solicitor has been assessed in a consistent way. And as you can see on the jigsaw there, you know, there are, I suppose, kind of 4 component elements to the SQE and what it involves from a qualification pathway perspective. Firstly, you will need to pass SQE 1 and SQE 2. And I'll come on to talk about those in a little bit more detail. As with the current qualification pathway, you'll need to meet our suitability requirements. You will need a degree or equivalent, and you will need to complete a period of qualifying work experience. And again, I will unpick what qualifying work experience is, you know, in a moment. So SQE 1, this is, you can see on the slide there, I suppose, the kind of the makeup of what's involved in the SQE 1, which is an assessment of an individual's functioning legal knowledge. It involves 2 single best answer assessments, and they will be completed over 2 days. And you can see there that there's that each of those assessments is 180 questions in total. The purpose of SQE 1 really is to make sure that individuals have the ability to identify core legal principles and apply them to, I suppose, the work in which a solicitor does, those kind of client problems, client transactions, etc. I think it's important for people to recognise that actually, you know, inherent in the SQE, both SQE 1 assessment and 2, that actually ethics and professionalism really kind of underpins these assessments as well. So hopefully that gives you a little bit of flavour as to what the SQE 1 involves. You can see there the types of areas of law, I suppose, that those 2 assessments that I mentioned a minute ago will cover. You know, I don't plan to go into too much detail about those, but I think, you know, you'd all agree that those cover the key practice areas and key issues that, you know, should be assessed. SQE 2 is a little bit different. What SQE 2 is designed to do is test the legal skills of a candidate. You know, testing the legal skills required of a solicitor. That assessment is broken down into, I suppose, kind of two parts. Firstly, there is an oral element to the SQE 2. And what that covers typically is interview, attendance, notes, legal analysis and advocacy. And that's carried out over 2 half days. And then you have the written element of the SQE 2 assessment. That takes place over a slightly longer period of time of 3 half days and involves undertaking 12 written legal skills assessments. And again, you know, just to reiterate there that it's really designed to test the competence of an individual wanting to become a solicitor in their ability to kind of carry out those tasks that, you know, a newly qualified solicitor would be able to do. Okay. Again, just a reminder there of some of the 6 skills that are assessed across both elements of the SQE 2 and the 5 contexts that those skills will be assessed in. There is, I think, just to point out, there is an awful lot of information about what these assessments look like and feel like on our website. So, you know, this is really just the kind of high level messaging. If you're interested in kind of drilling down a little bit to understand in more detail, you know, what's involved, have a look at our website. There's assessment specifications, kind of all marking schemes, etc. Everything is up there for people to take a look at. I just wanted to sort of, I suppose, expand really a little bit more on, I suppose, what are the practical, the practical elements of taking the SQE assessment. So at the moment, there are 2 exams sittings per year. Our view is that reflects probably the level of demand initially for the SQE2. However, kind of going forward, when this becomes the predominant way in which individuals qualify, then actually the number of settings will increase. And you're allowed 3 attempts in 6 years from the first sitting, to pass the SQE2. We were absolutely conscious that in considering how best we deliver the SQE, that there had to be a kind of a wide geographical network of how people can take the SQE1 and SQE2 assessments. So there are lots of places across the country in which you can sit the SQE1 assessments. They will be delivered through Pearson View centres. So most towns and cities have at least one Pearson View centre in them. So it is accessible in order for you to actually sit the assessment. Going back to the point I made at the very beginning, following up Roxanne's point, is that I think we're all acutely aware that one of the barriers to the current qualification pathway is the cost. It is prohibitive, and there is no guarantee that if you spend the money in order to become a solicitor, that there is a training contract at the end of it which guarantees you a job as a qualified solicitor. So again, with a view to increasing kind of diversity and access to the profession, it was absolutely critical for us to look at how we can make the assessments as open and cost effective as possible in order to help achieve that diversity. And you can see the prices of the assessments on the screen there. So kind of in total, really, you're looking at sort of under £4,000 to take the SQE assessments, both 1 and 2. I think it's worth just reflecting on that point of cost, that actually we're seeing a really, really positive response from the education and training provider market to the introduction of the SQE. There are lots of different types of SQE training being offered by existing and new providers. Some of them range from kind of master's degrees, which include SQE1 and SQE2 training, at the more expensive end of the education and training market, right down to some providers offering SQE1 or 2 training for as little as £500. So the initial signs are really positive for making the SQE affordable and helping achieve that diversity that I've mentioned. If you are interested, as to who might well be offering SQE education training provision, we have a list of providers on our website who have indicated to us that they will be making some form of SQE provision. Now, just to caveat that, we don't regulate or we do not accredit education training providers. These are organisations that have told us that they're interested in providing SQE training. So as with any decision you make, just make sure that you kind of do due diligence on the provider, and make sure that the course that you select is right for you. Just some information there on the dates of the SQE1 and two sittings. And to date, we've had around 2,500 individuals register a candidate account, and by a candidate account we mean going on to Kaplan, who will be delivering the assessment for us, going into the SQE portal and providing details of who they are and indicating whether or not they'd like to sit the SQE. And at the moment we have nearly 800 individuals booked to take the SQE1 assessment in November. So the signs are that actually the demand for taking these assessments and this pathway is there, and will only get better. Okay, apologies if this slide's a little bit kind of text heavy. I wanted to try and get across as much detail as possible, and again, just to kind of reiterate, what's on this slide is really just a summary, and please do go and check on our website, because there is a lot more kind of granular information. What this slide really explains is that actually we've introduced transitional arrangements, and what those transitional arrangements are designed to do is give candidates or individuals who are already on their way to becoming a solicitor, when we introduce the SQE, as much choice as possible about how they, which qualification route they go down. And we needed to do that because we recognize that a number of people may well, be starting or have started, courses that are on their way to becoming a solicitor. And what this means in practice actually is that, if you've already kind of started studying or training, you can choose to continue to qualify through the existing routes, or you can choose to do the SQE subject to certain criteria. So what I wanted to do is just pull out some of the detail of that. So the transitional arrangements apply to anyone who before the 1st of September 2021 has either started, accepted an offer of place, or paid a non-refundable deposit on the CPE or graduate diploma in law, the LPC, or has started a period of recognised training. So essentially, if you are on your way to becoming a solicitor in either one of those mechanisms, or one of those courses or periods of training, then you may well be able to qualify under the existing route, so long as you've accepted or met those criteria in terms of the 1st of September. For those that might well have sort of started a qualifying law degree, an exempting law degree, again, if you've kind of completed, started, or accepted an offer of place and paid a non-refundable deposit by the 21st of September this year, then again, this existing qualification route is still open to you. And what that means, if you're part of that cohort, is that you have until the 31st of December 2032 to qualify under the existing route, so long as those courses are available. What I suggest is that, obviously everyone's situation is completely different. There is, again, a lot more information on our website. So if you feel that you're in this group of individuals and you're not too sure about whether or not you should carry on down the existing pathway or wait for the SQE and go down the existing route, have a look at the resources on our website, because they will be able to probably help you inform your decision. Okay, I'm sort of conscious of not eating up too much time. Obviously, for qualified lawyers, the SQE, given that it's a single assessment at the point of entry to the profession, will replace the qualified lawyers transfer scheme at the moment. So, however, you can still, as with the previous transitional arrangement, qualify under the QLTS subject to meeting certain criteria. They are, again, quite complicated and involve a range of scenarios. So, if you have, or if you think you might be eligible to qualify under the QLTS, have a look at the information on our website. But essentially, from the 1st of September, individuals will, in order to become a solicitor, qualified lawyers, who want to become a solicitor, will need to have a degree in any subject or equivalent qualification or experience. You'll need to pass the SQE1 or SQ2, pass the SQE1 and SQE2 assessments, unless your qualification has an agreed exemption. And again, you'll need to meet our character and suitability requirements. There is a difference for qualified lawyers. Once the SQE is in place, that there's no requirement for you to have met our period of qualifying work experience. And that's because we, given the fact you're a qualified lawyer, we assume that you've probably got more than 2 years work experience. And just to flag up, that process for exemptions is open now. Okay, qualifying work experience is, if you think back to that jigsaw slide at the very beginning, it's a core part of kind of your becoming a solicitor under the SQE. The purpose of qualifying work experience, I suppose, is to give individuals who want to become a solicitor experience and exposure to the types of skills and competencies required in order to be a solicitor. And the reason why we felt that was important is that not only it kind of gives you experience of what it is to be a solicitor, but it also gives you experience and exposure to the types of skills that are assessed as part of SQE2. So that's kind of the rationale for introducing it. So what qualifying work experience really does, in practice, is from the 1st of September kind of make the training contract redundant as a regulatory requirement. We remove that prescription that you need a training contract in order for qualification. And what it means is that actually, qualifying work experience can be obtained in a range of organisations, both in the regulated, both in a regulated law firm, but also in a non-regulated organisation, so long as the work that individual doing is kind of delivering legal services and gives them exposure to some of the competencies. So what that does is really, really open up how people can get the experience in order to qualify as a solicitor. So again, going back to that point of diversity, not everyone will be chasing, the golden ticket of a training contract now. You can get your experience in a range of organisations, in a range of ways, and across, as the slide says there, it can be full-time, part-time, or some kind of hybrid combination of both. There are a couple of kind of caveats that we put around that flexibility. First is that, we say that it can't be in any more than 4 separate organisations that are providing legal services. So that's just something to bear in mind, but we won't prescribe, a length of what each placement should be. The other one I've mentioned is that it's got to be kind of delivering legal services, and it needs to be confirmed by a solicitor or compliance officer for legal practice who we regulate. But that solicitor doesn't necessarily need to have a practicing certificate. And again, lots and lots of information on our website about sign off, what it involves, what people should do in order to prepare for sign off, etc. And the other, I suppose, kind of advantage of our approach to qualifying work experience is that it can now be obtained. You can use any previous experience that you might well have accumulated towards qualifying work experience. So it can be obtained by a kind of previous or current role. We've outlined quite clearly what we think good qualifying work experience looks like, and that's again from a kind of an individual and an organisation's perspective. I mean, I think, without repeating what's on the slide, the key aspects for us are really that, organisations and individuals make sure there's some agreement that the work that they're doing constitutes qualifying work experience before anything has started, because that will help then avoid any kind of difficult conversations at the point at which qualifying work experience needs to be signed off. Make sure that the work that you're doing gives you exposure to some or all of the competencies. If you feel that there are some that you're lacking, have that conversation with the organisation. If not, go and perhaps get do some voluntary work in a law clinic, in a law centre, for example, to get exposure to other types of competencies. And I think the other point there is really just make sure that you record what you're doing, because that's the evidence that you'll need to be able to present to a solicitor or a CULP to say, look, we had a conversation about me qualifying as solicitor. This involves qualifying work experience. Here's my evidence that I've met the requirements. Can you please sign it off? I think I've probably touched on a lot of what the SQE offers in terms of opportunities for individuals. I suppose the only one to pick out there is really that, you know, apprenticeships, you know, that will be a valid pathway to qualification under the SQE. And again, the endpoint assessment of the apprenticeship is the SQE. And, you know, lots of opportunity, you know, if this is something you want to consider to take the SQE by self-study. You know, there is no regulatory requirement that you go to a provider or do a particular course. You know, you can devise your own learning, sit in your kind of bedroom and read textbooks and still take the SQE, so long as you meet all the other parts of that jigsaw. Just very quickly, the point on data at the bottom there is that, you know, once the SQE is embedded and up and running, we'll be producing lots of data about kind of pass rates, where people went to university, the courses they did, and we hope that will be used by potential solicitors to help inform their choices. And again, that's something that is missing under the current qualification pathway, we feel. Lots of opportunities for firms. I think, you know, lots of firms I've spoke to see this as a really good opportunity to get hold of their learning and development and their training and really align it with what their business is about. I touched on apprenticeships there. Again, lots of information. The advantage of the apprenticeship route, which is growing in popularity year by year, is that obviously the cost of training and the assessment itself is paid by, you know, through the apprenticeship levy, which probably means that you don't have to pay for it out of your pocket. Whoever's kind of offering you the apprenticeship will pay for it and reclaim that back through the apprenticeship levy. So again, if you're thinking of becoming a solicitor, probably worth having a look into the apprenticeship route and considering whether that's something that might work for you. And finally, and very quickly, just lots of ways there in which you can kind of keep in touch, get more information and resources from us. So that covers, I think, everything that I wanted to say, Roxanne. So I'm not sure on the kind of format of questions, but obviously if there are any, I can pick them up or address them as part of the kind of panel Q&A after.
Thank you so much, Richard. That was very, very, very valuable input into the SQE. I'm sure it's answered a lot of questions for students who want to enter after the GDL or after their LLB. I think the qualifying work experience is very, very important. And from what you said, removing the training contract element provides a lot of pathways for students who've just completed the LPC or who are looking for work but don't have the opportunity to gain a training contract. I think it's very important because a lot of students have had work experience and that would put them into an easier position to gain the qualification as a solicitor. So thank you so much, Richard. We do have a few questions, but I would just hand over to Dr. Victoria Stec, who is the head of the Bar Standards Board. And after she's spoken, then I would help and answer any questions anyone may have. So thank you again, Mr. Williams. I would now pass over to our lovely Victoria from the Bar Standards Board.
Thank you very much, Roxanne. I think you've promoted me. I'm not the head of the Bar Standards Board. I'm the head of authorisation at the Bar Standards Board, but thank you. And I will now try the screen sharing trick and hope that I get it right. Can you see my slides? Can someone just let me know whether you can see? Yes? Okay, fantastic, great. So similar to, as Richard was saying about the solicitor route, training to become a barrister has been through a massive period of reform. We were very keen to follow 4 principles behind all our reforms, and those were accessibility, flexibility, affordability, and maintaining high standards. So that's what's informed all of our rejigging of bar training, and I'll come on to tell you a bit about all of that. So Okay, just a very brief bit of background. The Bar Standards Board is the regulator, and we're responsible for setting and monitoring the standards of conduct for barristers. And we also set the training requirements for becoming a barrister. We're separate from the Bar Council, which is the representative body for barristers, and they provide services to support barristers throughout their career. But there is a very good guide to becoming a barrister on the Bar Council website, which I would recommend. So how do you train to become a barrister? Well, to qualify to practice, you need to complete 3 components of training, and I'll expand on these in a moment. So the curriculum for bar training is based on the competencies that are set out in this very important document that's called the Professional Statement for Barristers. This sets out the competencies that are expected on day 1 of practice. So that's the threshold level expected of you on completion of all 3 components of training. And you can get a copy of that from our website, and reading it would give you a very good understanding of what attributes you need to develop to become a barrister, and what skills and knowledge you need to acquire during your training. So I said earlier that there are 3 components to the training. Now, in the past, the old way of training for the bar was the only way you could do it was to complete the 3 components sequentially, and all of the providers of what was called the Bar Professional Training course were all basically delivering the same course, with obviously some local variations in terms of how they delivered it, but the course was pretty much the same everywhere. But now what we've done is to enable more variety in the pathways, and what you can see here is that there's a range of pathways to choose from. Now, the pathway that's the most similar to the old Bar Professional Training course is called the 3-step pathway, where you still do the 3 components. You do your academic, vocational, and pupillage sequentially. In the 4-step pathway, the vocational bit of it is split into 2 parts, and these are taken separately. So that means that you're not financially committed to the whole course right from the outset. You could either decide it's not for you after the first part, or you may not even be successful on the first part, and you may decide, yeah, that's not really for me. So that's one advantage of doing it that way. There's another way which is called the integrated pathway, and that's where some universities decide to combine the academic and the vocational, and that can be a very economical way of getting 2 things at once. So you get your academic degree and you complete what is needed to get to the point of being called to the bar in one go, and so we call that the integrated pathway. Now, we've also enabled within our regulations the possibility of an apprenticeship route. Now, the reason it's not yet available is that we haven't yet had any providers come forward with a proposal for that, but we are really hoping that will happen, and we are talking to some likely employers who might be interested in doing that. So we are hoping that does happen before long, because I know it is available for solicitors. So I'll say a bit more about each of the components. The academic component is obviously doing your degree. If you do a law degree, it must include 7 core subject areas, and you can find out what those are by looking on our website. If you don't want to do a law degree, you can do any honours degree that you want, and then you can do a kind of conversion course, like a GDL, so you don't have to decide right from the outset that law is for you. But the requirement that we have is that you must get at least a 2-2 in your degree, whatever it is. But you should note that that's the minimum requirement, and as you progress to pupillage, the competition for places means that recruiters often look for firsts or 2-1s. But that's not always true. There are some places that recruit without knowing what class of degree you've got or where you got it from. So before you start your vocational training, after you've got your degree, what happens then? So before you start, you need to join one of the 4 Inns of Court as a student member. And you also need to pass the bar course aptitude test, known as the BCAT. Now, the BCAT is not something you have to study for, it just tests your aptitude for critical thinking and reasoning. It doesn't test legal knowledge, and it doesn't require you to have had any legal experience. Its aim is just to try and ensure that those doing vocational training have the aptitude to succeed. As well as doing the vocational course, you need to attend what are called qualifying sessions at your inn. And this is where your inn will help you to network with barristers and understand more about what it's like to become a barrister. And the qualifying sessions always have an educational element. And there are 4 inns to join, and whichever one you join, they will offer you lots of support while you train through your career. The inns are also a key source of funding, and they offer a variety of scholarships to help you meet the costs of your training. As another important source of funding might be your bar course training provider. And you might need to do some research about what kinds of bursary and other benefits each of them offer. So that moves us on to the vocational training courses, and you can see here we've got the list of 9 providers who offer the course across a number of sites. Some of them offer it on 3 or 4 different campuses. So this is where they are. There's one provider that's still in progress, it isn't authorised yet. That's the one at the bottom, Hertfordshire, but the others are all offering bar training courses. So a bar training course usually takes a year and involves taking exams, and the civil and criminal litigation are exams that are set and marked by the BSB. And many of the training providers offer flexible options with part-time routes, so that might be more suitable if you've got to work while you're still studying. And the prices do vary, but they begin at around £12,000 for the whole course for the year, which includes everything. So again, on our website, you can find out exactly which provider offers which course and how much it costs, and whether it offers part-time or all the different options. So once you've completed your vocational training exams and the qualifying sessions, the next stage is being called to the bar by your inn. And at that stage, you could call yourself a barrister, but not in relation to supplying legal services. You're called an unregistered barrister. And you can stop there if you wish, but if you wish to go on to practice as a barrister and to appear in court, and to take cases, then you need to complete the final component of training, which is pupillage. And all pupillages must be advertised on the Bar Council's pupillage gateway, and recruitment has to be in line with the timetable that we specify. Now, some pupillage providers will expect you to know your vocational course results before you apply. Others accept applications even before you start your vocational course. So they do vary. And during your pupillage, you'll be learning on the job. You'll be supported by a pupil supervisor who ensures that by the end of your pupillage, you're going to be ready to meet those competences in the professional statement. You also need to pass a BSB exam in professional ethics before you can successfully complete your pupillage. That's a new thing that's coming in from next year. Pupillage is usually 12 months unless it's part-time, and it's split into 2. There's the non-practicing part and the practicing part. So at first you'll be shadowing your supervisor, but in the second practicing part, you will conduct some cases of your own under supervision. Most people do their pupillage in barristers' chambers, where self-employed barristers practice, but there are also other organisations that actually employ barristers and train pupils, such as the Crown Prosecution Service and government legal departments, and even some solicitors' firms. And the minimum funding that you would receive during pupillage is set by us, and it increases annually. and that's £18,960 for pupillages in London and £16,601 for outside London. But many pupils actually receive significantly more than the minimum, some up to even £60,000. So there's great range there to investigate. So when you're applying for pupillage, as I say, there are lots of different types of pupillage, and the Bar Council Gateway website, pupillage fairs are a good way to find out what's on offer, what's available. And it's a good idea to go to the pupillage fairs while you're still at university, while you're still doing your academic course, to start to get an idea of what's on offer and what they're looking for in their pupils. We now require organisations to provide lots of information about their pupillages on their websites and to say what they're looking for. Experience like mini pupillages are a good way to get a taster of what life's like as a barrister and to demonstrate when you make your application that you understand what being a barrister is all about. It is, as I'm sure everyone is all too well aware, a very competitive profession. But you do have 5 years after completing your vocational training to secure pupillage. And while a lot of people may be unsuccessful at their first attempt, the statistics do show that the success rate does increase over time. And you can find more information about all these statistics on our website. So just to speak briefly about transferring qualified lawyers, whether you're qualified in a different jurisdiction or you're qualified as a UK solicitor, the process is the same. You apply to transfer to the Bar of England and Wales, and we would assess your application against the requirements of the professional statement and then give us a decision as to whether or not you're required to complete any part of any of the components of training for the Bar. So it's quite straightforward, but it is on a case-by-case basis. So after hearing all of that, you might be thinking, is the Bar for me? And what you might be wondering whether barristers fit your preconception of what a barrister might look like. That's a good question. And of course, very important to the Bar Standards Board is thinking about diversity at the Bar. And this just shows a bit of a snapshot of what the practicing bar looks like and what pupil barristers look like, and in terms of ethnicity and gender. And although obviously change takes time and change might not be happening as fast as anybody would like, you can see a difference between the existing practicing bar and the makeup of pupil barristers. So it's going in the right direction, but the Bar Standards Board is doing a lot of research on this. And again, there's a lot of information on our website that you can read to see what we're doing. So I hope that is a good sort of snapshot of where we are with things, and any questions?
Thank you very much, Dr. Victoria Stec. That was a very, very interesting insight into qualifying as a barrister. We do have a lot of questions. I am going to answer a few, and hopefully we would get further insight into the SQE and also qualification into the bar. It's very interesting to see how the ethnic and gender makeup has changed over the years. And hopefully, especially with our organizations, we would see more people of the ethnic minority joining. It would be wonderful to see that progress and change. Okay, so I'm going to ask the first question to Dr. Stec. It's from Mariah. She says, hi, I'm coming towards the end of my LPC and master's study. Okay, so this applies to the SQE, sorry, to Mr. Williams. She says she's coming towards the end of her LPC and master's. She was wondering whether the 2-year qualifying work experience would apply to her without doing the SQE examinations.
Everyone will need to take SQE examinations, the SQE1 and SQE2 assessment. what qualifying work experience does is as I kind of mentioned, give you the experience of what it is and some of the skills involved to practice as a sort of a competent solicitor. So yeah, you will need to do 2 years in order to meet our admission kind of requirements under the SQE, and you will still need to pass SQE 1 and 2.
Okay, thank you so much. I'm going to move on to a few other questions. Dr. Victoria Stec, this is for the bar. So does a practicing lawyer in another jurisdiction, it's also for Mr. Williams, do they need to do the SQE, or do they need to undertake maybe a qualified barrister's test to enable them to practice in the UK? So Mr. Williams, you can start with that answer, and then I'll move on to Dr. Victoria Stec.
We currently have obviously the Qualified Lawyers Transfer Scheme, which enables lawyers, solicitors qualified in the lawyers qualified in the jurisdictions to become a solicitor. That process is essentially subject to a few minor exemptions will be replaced by what is required under the SQE. So I think if I quickly just run through that, it might pick up a couple of the other questions on kind of foreign lawyers as well. So if you are a qualified lawyer and you want to become a solicitor, you're going to need a degree in any subject or equivalent qualification or experience. You're going to need to pass the SQE 1 or 2 unless your qualification or experience gives you an exemption from SQE 1 or 2, and I'll come on to that in a second. You will need to meet our character and suitability requirements. You will not need to demonstrate to us 2 years period of qualifying work experience. So in order to be granted an exemption, because I think there was a question about can you get an exemption from SQE 1 and SQE 2 that was asked as well. In order to be granted exception, the qualification or experience must be equivalent to the whole of either SQE 1 or SQE 2. There is no kind of partial exemption to kind of the parts of SQE 1 or 2. So, if you are looking for an exemption, what I suggest is, what you'll need to do is to be able to demonstrate that your qualification or your experience is kind of based on a legal system that is not too dissimilar from what we have in England and Wales. And the reason for that is what we're looking for is to some degree is kind of equivalent legal knowledge, so that if we did admit you under the exemption route, we have our assurances that you have the right knowledge to practice safely in England and Wales. And I'm sure you can all agree, that that's something important for us that we need to do. So we have granted exemptions to particular jurisdictions and particular qualifications already, and a list of those is on our website. So if you are a qualified lawyer thinking about becoming a solicitor under this route, go and have a look at our website. You'll be able to find some of the jurisdictions where we've already granted an exemption, and it will highlight what that exemption is from, whether it's SQE 1, 2, or perhaps both.
Thank you very much, Mr. Williams. I do understand what you mean, because with the Commonwealth, we have, for example, subjects that interrelate with the Commonwealth, which is England and Wales. So it's easier to say that if you are thinking of joining, or you be considered being granted an exemption, it is advisable to have something that is closely related, so presumably the Commonwealth, to enable you to join the practice as a solicitor in the UK. So thank you so much for your insight. Dr. Victoria, a lot of students have come with questions concerning transferring from Commonwealth jurisdiction to qualifying as a barrister in the UK. So from the questions that I've gathered, a lot of questions that are similar are mainly qualified lawyers, perhaps from Ghana or Ghana or Nigeria, that are wondering, okay, I've qualified in my home country. Can I transfer as a barrister after qualifying in my home country to the UK?
And the answer is yes, you can. As I mentioned, we don't have any blanket exemptions. We do consider every application on a case-by-case basis, because even if someone has qualified, you might think that two people who've qualified in the same jurisdiction would be the same, but inevitably there are individual differences, and one person might have had different experience to the other. So we do consider them on a case-by-case basis. So yes, you're able to apply to transfer to the Bar of England and Wales, and we would consider your application and the full range of your experience. So it's in your interests to say exactly what you've done and whether you do have any experience of England and Wales, because that could make a considerable difference if you'd spent any time at the Bar of England and Wales or worked internationally in other ways. And then once we've considered your application, we would give you a decision that would say which aspects of each of the components we think you should pass assessments in. So you might, for instance, be required to take some of the assessments from the vocational component, and you might be required to do some pupillage. You might have a reduced pupillage, say perhaps 3 months, depending entirely on your experience. So the answer is yes, but it depends. Yeah.
That was a very insightful answer. I like that, because then it gives students the opportunity to realize that yes, you can qualify, but all applications will be considered on a case-by-case basis, which is very accurate. Thank you for that. One other question I was asking, in terms of INs that you may join, you mentioned that to become a barrister, you would have to join an IN. Do any of those INs offer scholarships for funding, for example, for a pupillage? Do any of those INs offer scholarships towards that?
Oh, for pupillage, that's a good question. All of the INs offer scholarships for the vocational component. I must admit, I don't know whether the INs actually support pupillage, because it's the responsibility of the chambers to provide the minimum funding. I can go away and find that out. That is a very good question, and I should feel as if I should know the answer to that, but I can find out and let you know.
No worries. Thank you so much. We are getting closer to the end. I'll take a few questions from what I've got from my chat just now. I think more towards Mr. Williams. Thank you so much, Dr. Victoria Stec. It was very insightful to have your knowledge on the Bar Standards Board, and it's really interesting to see how the career is progressing. Very, very, very insightful. Thank you so much, Dr. Victoria Stec. Mr. Williams, again, if you wouldn't mind reiterating for those who've just joined, could you give us the start date for the SQE1 and SQE2, and just a very short structure on the exams? Because I remember you mentioned that there would be an oral component and then a written component. So how many days is that spread across, if you don't mind reiterating for us once more?
No problems. I mean, the SQE is, as I suppose, a set of regulatory requirements for admission to become a solicitor comes into effect from the 1st of September. The first actual kind of sit down SQE assessments will be SQE1, and they will happen in November this year, and then the SQE2 assessments come in spring next year, sort of April. So what, in terms of I suppose what SQE1 will assess is the functioning legal knowledge of a solicitor, and that involves essentially 2 single best answer tests, essentially. So that's two sets of 180 questions that need to be completed, and they are offered over 2 days. So essentially it's kind of one assessment per day. In terms of SQE2, that's very much about testing the practical legal skills required of a competent solicitor, and that's broken down into 2 elements. So there's an oral element to that. So there's an assessment around, what are the skills required in order to kind of conduct interview attendance, legal analysis and advocacy. And they are carried over 2 half days. So essentially that looks like pretty much 2 assessments kind of per day really. And then the other aspect of the SQE2 is the written assessment. And then you've got 12 written legal assessments, which are over 3.5 day period. So hopefully that gives you kind of the breakdown. There is an awful lot of information on on the SQE website about when, how, why, and how these assessments lined up. So if you wanted a little bit more detail than I've given, I suggest people go and have a look at that information.
Thank you so much. It's interesting to see how there's going to be a departure from mainly what we've known before, the classroom setting with the LPC, to more of a practical skills assessment. And as you mentioned before, it would give more students the opportunity, whether it's studying or learning remotely, in the classroom, private study, or those who are working. It kind of opens more opportunities for students across the world to study. So I think it's a very, very amazing departure. I have one last question. It's from Simran, and she says, would you recommend law students in their second year to take the SQE or the LPC? I'm sure everyone is different in their personal preferences, but in terms of how this route is going, what would you say on that?
I mean, I think it's a tad tricky for me to answer without knowing people's individual circumstances, and I wouldn't want to kind of mislead anyone. So I think the best thing that if you are an individual in that position is go to our website, have a look at the information available, use it to try and help you decide what's best for you. There is a decision tree on our website where you can kind of put in various bits of information about your circumstances, and it will help you come up with whether the SQE or the LPC is right for you. So I think that's probably the best advice I can give to that question, Roxanne.
Final point, I just wanted to know, for the SQE1 and the SQE2 for law students, how long does it take? Because from what I understood from what you said, the intake dates are in November and then April. So is it a year in total for the SQE1 and 2?
Is this taking the assessments or?
Yes, taking the assessments.
Yeah. I mean, essentially, it's the difference between November and April. That's how long it would take to sit both SQE and what 1 and 2. And obviously the reason for that is partly because you've got Christmas, it's slap bang in the middle, but also we need to make sure that we need to give people the results from SQE1, etc., before kind of going on to SQE2. So that's why there's a little bit of a gap in between both assessments.
Okay, thank you so much for your input, Richard. That was very, very insightful. Again, if anyone is looking for any further information, feel free, as what Richard said, to look on the SRO website just to get more of an insight as to the SQE exams and the departure now from the traditional training contract to now qualified work experience. That would make it, in my own opinion, easier to transition as a solicitor. So thank you very much, Dr. Victoria Stec. Thank you also, Mr. Williams, for your input. It was lovely to have your very, very lovely presentation, Richard and Victoria, and it was amazing to have you on here. We would wait for our second part of the panel, which would be the careers panel. But again, thank you so much for your time. I really appreciate you, Mr. Williams and Dr. Victoria Stec, and hopefully we will hear from you soon and in the future. Thank you so much.
Okay, thank you so much.
Thank
Bye-bye.
you very much. Bye.
Everyone, and welcome to the second part of today's session. This is hosted by the British Nigerian Law Forum, or BNLF for short, for those of you who don't know us. I hope that those of you who attended the first session picked up some really useful information, and hopefully this session will be just as informative from the careers perspective. So as an introduction to myself, my name is Afolarin Awosika. I'll be hosting this evening's discussion. I'm a member of the BNLF Junior Lawyers Division Planning Committee. And for those who don't know the BNLF, we're a bilateral organisation as a forum of communication for British and Nigerian lawyers. BNLF is recognised by the society, the SRA, the Bar Standards Board, who you heard speaking today, and the Nigerian Bar Association. We've been around for 20 years now, and for those of you who might be interested, we're looking at putting together an event for our 20th year anniversary later this year, so keep an eye out for that. We have a number of divisions, including also Junior Lawyers Division, Business Law, Family Law, Immigration Law divisions, as well as others. The Junior Lawyers Division in particular is aimed at creating a platform for lawyers, students based here in the UK and in Nigeria to work and discuss common interests and exchange ideas. We do this by hosting seminars like this, various other in-person events, hopefully soon, activities and facilitating memberships. One of my colleagues, who I think is attending now, will put some more information in the group, and we'll put some links to our social media pages so you can keep up to date with the things we're doing. So just some housekeeping very briefly before we start. This is being recorded, and we will make it available on our website and the YouTube channel after the session, just in case you want to watch anything again. So without any further ado, we have an excellent panel of speakers today who I think will provide you with unique and diverse perspectives on their respective careers. We've got a barrister in Kweku, we've got a solicitor in Caroline, we've got a compliance officer in Desiree. So as I said, broad and diverse range of perspectives here, which is interesting and useful for all of you. I'll leave some time at the end for questions. So as and when a question comes to mind, just put it in the Q&A box, which hopefully will be in the bottom panel of the Zoom screen, and I'll do my best to get through all of them at the end. Okay, so just going around in the order of my screen, Caroline, please can you tell us a bit about your background, your education, and your route into your career?
Sure. So hi everyone. Really glad to be here. So as Afolarin said, my name is Caroline. I am a junior associate at Latham Watkins, which is a large global international law firm. I didn't study law at university. I studied politics and international studies. And then in my final year, I decided to switch to law. So I did the GDL and then LPC, and then started my training contract at Latham and Watkins. Once I finished my training contract, I then qualified in the data protection and technology transactions team. And I then set up a transfer to move to the Silicon Valley office, which is now known as the Bay Area office, as we also have an office in San Francisco. So I've been at Latham now for the past 4 years and out in Silicon Valley for should be nearly 2 years now.
Thank you, Caroline. Very interesting. I'll come on to your relocation to the Bay Area very soon, but thanks, that's interesting. Kweku, same question.
Right, my name is Kweku Aggrey-Orleans, and I'm a barrister. My course towards being a barrister involved obviously school, university. I did do law. I did English law and French law at the University of London, King's College London, and the University of Paris 1, the Sorbonne. I came back, I went straight and I did the bar course. I then hung around a bit in the hustle for pupillages. I got my pupillage pretty much on my call night, a real hustle, actually done by my dad as opposed to me, but he's a hard worker. And then followed by a third six at a criminal set, and then followed by another third six at the 12 King's Bench Walk, where I currently am. And so if you want to follow my model, which is not recommended, but it does show some of the characteristics needed at the bar, namely you've got to have your hustle on, you've got to be determined.
Thank you, Kweku. And you're also part of a law firm in Ghana, which we'll come to later on Perhaps
Yeah, very well. So I'm a partner in a law firm in Ghana. I qualified there in 2010 in Ghana, given that we run a common law system together with our own customary law system. It was a very short course, which has now been lengthened since I took the course. And it's one that I'd recommend both for Nigerians and Ghanaians. I think it really does give you a lot of kudos in either legal market.
Brilliant. Thank you very much. And finally, Desiree, how about you?
Hello, thanks for having me. My name is Desiree, and like many of you, I've also studied law, and then I decided to do my legal practice course. I'm currently an AML KYC Specialist for Fiserv, which is a fintech company. And you might think, what is an AML KYC Specialist? So that's basically an individual who works for a company that works in a regulated sector. So fintech is a regulated sector, but it might not be as regulated as an investment manager, for example. And my job is to collect and review customer information and assess the money laundering, tax fraud, and terror financing risks. So that's what I do.
Thank you, Desiree. And just on you probably follow a less conventional route after studying law and doing the LPC. Why did you decide to do a career in AML and the field you're currently in? Can you explain a bit about your job? What does a typical day look like to you?
So at the very beginning, after I studied law, I wasn't really sure what I wanted to do afterwards. And I kind of saw that most of my friends were doing the legal practice course as well. And I was like, okay, I might as well do it. Had no expectations really. And then while I was doing the legal practice course, there was a module called Professional Conduct and Regulation. And I really enjoyed that. And I was like, okay, that's a bit of me. And so I was studying it and I researched a little bit and I saw that compliance kind of aligns with this type of area of law. And so I digged a bit deeper and, just started applying for roles and, managed to get my foot at the door. And so my day-to-day tasks include analyzing documents provided by clients and advising on whether or not further information is required. I also complete onboarding tasks such as reviewing and processing new customers and drafting appropriate due diligence requests to be sent to prospective customers. And I liaison and communicate with the client-facing team and also with the compliance team. So compliance has got loads of tasks. So these are just a few tasks. And yeah, that's me.
Great. And you mentioned that the one course in particular during the LPC you found was useful to perhaps your day-to-day tasks. Can you think of anything else on the LB and the LPC that you found particularly useful or might be relevant for students who are listening in?
I think there might have been, I'm not sure, I might have gotten that wrong, but I think it was part of my property law sector where we were talking about enhanced due diligence and etc. So basically money laundering, there was a section of money laundering that we talked about during my property law workshop, and that was definitely a bit of me as well. And also the Proceeds of Crime Act 2002 is what I would definitely recommend for anyone who is interested in compliance. Have a look at that part of legislation, because this is basically what compliance is about, so yeah.
Okay, thank you very much. And Kweku, moving on to you. As I mentioned earlier, you're a barrister here in England as well as a partner at a law firm in Ghana. What would you say the proportion of your practice is in England as compared with?
Well, in terms of time, I spend about 5 months a year in Ghana, and then the remainder of my time here.
Okay.
I suspect that's largely brought about by the fact that I've got kids and they're being educated here. So that has prevented as such a full-time move in any direction.
And would you say you prefer to be in Ghana or you prefer to be here? Which jurisdiction you prefer practicing in generally, if you don't mind?
I mean, I don't know. Increasingly, as I as I spend time in Ghana and I spend time in the courts of England and Wales, I see massive drift in terms of the way in which law is practiced, in terms of the ethics that surround it, in terms of the supporting system that surrounds it, that surround the profession. And I also feel that Ghana and Britain sometimes feel like two completely different worlds. And I mean, that's not just a matter of development. It is also a matter of, in my view, cultures and how rules are enforced, implemented, introduced, etc., etc. What I would say to the group of students on this network is that the reason I decided to qualify was I had been called to the bar in 1998, and I'd been swashing around for 12 years in England and Wales. And I scratched my head one day and I said, hang on, you know all the laws of England and Wales, but you don't know any laws about your own country, right? So what are you going to do? Is this a moment you can upskill? And fortunately, the course in Ghana was only going to be a 3-month course. It also timed perfectly with my daughter and how her age, school, and everything like that. So as such, it was my last chance. But having gone to Ghana, I think my practice, even in the UK, has been enriched. And that is because you've seen the practice of law in another jurisdiction in the same way as any English barrister going over to Ghana will be enriched. Any Ghanaian barrister coming to England will be enriched. Because it shows some of the core themes that are important, some of the core themes that actually may not be so important. Look at that wig and gown. Wig and gown in Ghana, wear every day. Won't hear you without wig and gown. Here, wear a wig and gown, you're almost doing fancy dress in front of a judge. So these are some of the sort of strange departures. But to this august forum, I'd say, listen, if any of you have the opportunity, and you heard from the lady from the Bar Standards Board who gave a very good précis of the Bar Standards Board's attempt to increase relevant to this forum diversity, that you should all look into if you can qualify in your respective countries, be it Nigeria, be it Sierra Leone, be it Ghana, wherever it is, whether it is after or before you do your qualification here. Because we haven't touched on it, but it's always an underlying theme whenever I speak on these fora to do with the law and to do with access to the law, pathways to the law. The question of diversity always comes up, okay? And to that I say, my first starting point is, yes, you do, on the statistics at the bar, it does seem as if ethnicity plays a part. But what is more interesting is to try and unpick some of the other elements. But alongside that, I do also say to the students and everyone else, empower yourself. You don't want to go to a firm that doesn't want to hire you, right? You have value to add. And so don't get too hung up on people saying no to you. Perfect yourself and find the people who say yes to you. Because ultimately, we are living, certainly on this side, in the city of London. London is an amazingly challenging town, city, that, whether you like it or not, is trying to improve, right? And you can find someone who is going to find you a safe haven. And also, don't discard or disregard the qualifications you can have from back home, because those are still institutions, educational institutions, legal institutions of value, right? So let's not devalue our own qualifications in front of the qualifications here in the UK. I digress, but that's why I did the qualification in Ghana, because I needed to upskill. I needed to find out more about what my own laws were as Ghanaian. And also, I realized that it was going to be very much a feather in my cap, second string to my bow, etc., because now, interestingly enough, I'm able to advise as an expert in cases in which Ghanaian law apply, but instructed here in London.
Yeah, of course.
So in that way, I've gone full circle and ended up in a role which is as such other than a barrister, because now I am an expert witness as opposed to who's legally trained, as opposed to the other way around. Yeah. So I found it a very useful skill.
And just on that point, quick, interesting you mentioned that. One of the members of the BNLF, Oban Sugbe, who I'm sure you know, he is dual qualified both in England and Wales and in Nigeria. He's actually QC. He's a silk in England and Wales, as well as a silk SAN in Nigeria. And I think he'd tell you that he's found that his practice in the UK has been enriched by being a member of the Nigerian bar and being introduced, I guess, that avenue to international clients who might be doing business in Nigeria, who might have a London-seated arbitration they're instructing on. So do you find that there's some overlap in your client base? Do you represent some clients in Ghana who might have some international work that might lead you to them in England as well?
Yes, but I say with deep regret that Ghana is still in the state in which it tends to farm out its most lucrative, in terms of being a lawyer, arbitrations to the classic magic circle firms, be they the American magic circles that have suddenly come in. Whiten cases very popular in Ghana at the moment, and traditionally what we used to get, which was lots of Linklaters. So there is another discussion to be had in terms of, but with our own sort of governments, with our own attorney general's offices, in terms of how they go about selecting the lawyers who do the work. But yes, in theory, I certainly know the likes of Oba, I mean, massively talented individual himself, but also he has the benefit of coming from a country that has a massive population, I would say, in terms of entrepreneurs. It's got a much bigger and wealthier population of entrepreneurs than Ghana does. And so it's very likely, and also it seems in Nigeria, there is a real pride in taking on and instructing a barrister from Nigeria for cultural assimilation reasons, in a way that, with regret, in Ghana we haven't quite got to. But yes, in theory, he's completely right. It does enrich your practice, and I've given you an example of how it enriched my practice. But also, there have been arbitrations I've dealt with, yes, but there haven't been enough, and that's my problem.
Yeah, hopefully many more to come. Thank you, Kweku, and I'll pick back up on that point a bit later. Fine. So you are qualified in England and Wales, but you work in the Bay Area, as you explained earlier, even though you're currently in London. Can you just explain how that came to be, why you chose to relocate, why the Bay Area? I know Latham Watkins is a massive firm and you have offices everywhere. Why in particular that location?
Sure. So I'll try my best to give a summary without giving my life story. But it all...
My story is fine as well, Carol.
Okay, we'll be here for a while. So I actually started to develop an interest in technology whilst I was in university. It was mainly from my internship at Bloomberg. So I always had tech at the back of my mind as an area of interest. So once I started my training contract at Latham, my first rotation was part of the technology team. So through that rotation, I got to go to client events and speak to other lawyers who had specialized in technology. So I always had it at the back of my mind that it was an area that I was really interested in. And throughout each of my rotations, I tried to continue to develop that. So as you said, Latham is an international law firm. So people move offices all the time. And whilst I was training, there was an associate who trained and then moved to Silicon Valley. So I knew it was an option. I knew it wasn't something that was done quite often. But I just thought, well, if she did it, then why can't I do it? So it really was based on my interest in tech, and I knew that I wanted to specialize in that area, and I found the clients really interesting. I found the industry really interesting as well. So once I finished my training contract, I basically just reached out to the office and introduced myself and asked if I could come. And luckily at the time there was a business need for more associates. So after that, it was pretty much a straight road to transfer. So I think in some ways it was luck because they needed associates, but also it was because of my interest. So that's kind of how it happened. I'm sure I'm probably missing out a lot of factors in there. You obviously need to think about visas when transferring, and also you need to qualify in California. I'm currently in the process of qualifying in California, and the great thing about practicing over there is that you just need to do an exam, pass a moral character test, which I'm sure no one would have any issues passing, and then it's a done deal. So that's kind of my background.
Okay,
in terms
so you have to pass the California bar in order to practice, regardless of whether or not you're being an advocate in court or anything else. You have to be a California lawyer in order to work in the office.
So you can practice temporarily without being qualified in California. So that's what I'm doing, but you can't litigate and you can't hold yourself out as being qualified in California. So all the matters that I'm on, everyone knows that I'm just English qualified and I can't go to court until I'm officially qualified in California. So you basically end up working as if you're still a trainee until you're officially qualified. So all your matters need to be supervised.
Yeah, understood. Kweku very helpfully took us through the different nuances between working in Ghana and working in England. Can you explain any of the differences that might apply between the area and England, the difference in working style, culture? Which do you prefer? Are you planning on coming back to London anytime soon, or are you happy out there?
I'm really happy out there for now. I did miss London, I have to say. But no, I would say the main differences I find between the two offices are the types of matters that I'm working on. So in Silicon Valley, I work primarily on technology matters with tech clients and founders, which is exactly what I wanted to do. Whereas in London, I would say we have a little bit more of a mix. If you're sitting with a tech team, you do still primarily work with tech clients, but you may end up working with other types of businesses as well. In terms of culture, the London office is bigger. The Silicon Valley office is actually growing a lot because we've been having a ton of tech deals. But when I was still physically going into the office before COVID, I did notice that it was a lot smaller than the London office. So I would say that's probably another key difference. But the great thing about that is that I end up getting a lot more responsibility and I get to work on things that are way above my level. So I've really enjoyed it. Obviously living in California as well, and having great weather in Silicon Valley is a plus. But saying that, I was only a trainee when I was in London, so it's quite difficult to compare the two, as I'm sure my experience would have been different if I was an associate in London. But I really enjoy it, and I think it was a great step for my career, and I feel very supported out there as well. But lastly, I would say, because Latham is global, you work with a lot of different offices. So in the US, I maybe work with the LA office or the New York office. So you don't just work with the Silicon Valley office. So regardless of where you're based, you would always have a mix of interactions with different offices.
Yeah. Yeah, I think that's the beauty of working at an international law firm for those who are interested. It's never really limited ever to one jurisdiction, regardless of what department you're in. But I'll come on to advice you would give to to students who are considering working in international law firms a bit later. So going back to Desiree, as I mentioned, I guess your chosen career path, as I said, was a bit less conventional than Kweku's or Caroline's or other people who are in the LPC or the GDL. What advice would you give to students who might be considering pursuing a career in AML or compliance as to how to get more information about which firms to apply to, what particular areas of AML or compliance they might be interested in?
I would say just try and apply. I feel like even if you don't have any experience, you should still apply. I, for example, got my first role without having any experience in compliance. But what I did, I researched a lot. I researched a lot about compliance. I Googled, I went on Indeed, I went on Reed and tried to look for similar roles, tried to see what the job description is saying, tried to research about the job description, tried to understand, tried to visualize how this would look like. And if I didn't understand anything, I just, ask people who are in that field as well. If you are interested in compliance, you can message me and let me know. I would love to help out, because somebody helped me get in this role as well. So I would love to help. So if you're interested in compliance, just hit me up. So yeah, just apply. I would definitely just try applying, do some research about it, try to network if you can, because that's the thing. One thing I love about compliance as well, there's so many opportunities for career progression. So there are loads of certificates that one can get as well. I would recommend again some experience before doing a certificate, but you can always get a certificate if you know that this is an area that really interests you and you want to stand out from the crowd. Then I would recommend that as well. So yeah.
So there are exams you'd say that you need to do after you start a job in AML and compliance. What kinds of qualifications and certificates have you got, and would you recommend to others who might be considering a career in AML compliance?
Okay, well, I do have a law degree. I've done my LPC as well. I've got a master's in law too, and I'm currently studying for an anti-money laundering specialist exam with ACAMS. So that is just, it's just to stand extra out of the crowd and also try to develop, in my career path as well. So there are loads of institutions. I mean, there's ACAMS, there's ICA. These are like the two most well-known ones, I would say. I went for ACAMS, it's just an American institution. So if I'm qualified there, I could work in America as well. So there is endless of opportunities, I would just say do your research, ask around, yeah.
Thank you, Desiree, and we'll make sure to put your email address in the chat function. So if anyone
sure, hit me up.
And Kweku, I know that there'll be a lot of people tuned into this panel event who are based in probably Nigeria, also perhaps Ghana, other foreign jurisdictions, that are considering making the move from Ghana, Nigeria cases to England. I know you did it the other way around, which arguably might have been a bit easier because, as you said, the course was only. What advice do you give to people who are qualified as barristers or barristers and solicitors in Ghana, Nigeria, and other places who are looking to make that transition here? What are the differences in the areas of practice, the education system, and so on and so forth?
My overall advice would be hold the line. Respect the fact that you have been called to a serious bar. I mean, Nigeria is a serious country. So respect that. And then in terms of what to look out for, I'm afraid I don't know whom you contact the Bar Standards Board, but there's no doubt a process that we heard from slightly earlier in relation to how you actually get to qualify. But in terms of acclimatizing and being able to be efficient on the ground, I would say it is looking at the way in which English barristers perform advocacy. and how they temper the questions. My experience in Ghana is that Ghana has tended to be quite aggressive once you get to the law courts, as opposed to here, where actually I can have a very civilized conversation with my opponent and still go in and cross-examine someone who might be lying, but in a very easygoing way. Yeah. Whereas I find that in Ghana it might be slightly more judgmental in the way in which you cross-examine someone. So get used to the local practices, and also try and draw from your own jurisdiction serious cases that you've done, and compare how they would be dealt with here, so that you're easily able to ascertain what the differences are within the system. So I think whenever you go somewhere new, it's often quite important to be able to know just how far away from your own comfort zone, from your own way of doing things you are. And nowhere is it more important than in the law, where you want to seem as if you know everything, and even though you don't, and you of course are, as a barrister, the point person for your client within the court atmosphere.
Yeah. Thank you very much. That's very helpful. And Caroline, I think there'll be a lot of people, I can really see the questions rolling in, who'd be interested to know how you got a trade contract at Latham Watkins, what the process was like, how you went about doing your research on various firms to apply to. So can you just give us a bit of a recap of what you did, what the process was like, what the interview was like, and any bits of advice you would give to some of our attendees who might be looking to apply?
Sure. I'll try to put myself back in that mindset, the hustle mindset.
Not good memory, I can imagine.
PTSD. No, I'm kidding. Actually, no, I'm not kidding. But no, as it's already been said, definitely research is very important. I decided to focus on, I think it was around 10 law firms when I was applying. There's some people that send out maybe 40 or 50 applications. I knew that I just wanted to focus on a couple. So I did a lot of research, figured out what kind of training contract I wanted to have. I knew I wanted to have something that was very hands-on. I didn't want to feel like I was one of 100. So I was more attracted to the American law firms as opposed to the bigger law firms. And then I just went to a ton of open days, just because I didn't study law. I also don't have any lawyers in my family. Parents didn't go to university, so I don't have any contacts in the industry. So it was very important for me to put myself out there and speak to people that had done it. So I went to a ton of law firms, met the lawyers in person, and then from then I kind of narrowed down on which law firms I felt like I would be best suited to, and also just gauging the personalities of the associates and the partners to figure out if it would be the right cultural fit. So I then did a vacation scheme at Kirkland and Ellis. I only did one vacation scheme. I would definitely recommend trying to do as many as you can, as that's really how you get a window into the law firm. So I didn't do a vacation scheme at Latham Watkins. I just applied directly. So after all the hustle and the grind in my final year of university, I got training contract offers from Latham and also from Clifford Chance. I would say my internship at Bloomberg, which is not related to law in any way whatsoever, actually ended up working in my favor because I was able to get a graduate offer from there. And I was able to get foundation on the financial markets and the business world. So I took that experience and applied it to law. So if you don't have experience in law, whatever experience you have, you can always talk about the skills that you gain from those experiences and then say how you would use it as a trainee in a legal context. So just to summarize, go to open days, research as well, and then once you do get into the law firm, I would say the 2 years I was doing my training contract, a lot of my friends always joke that they didn't really see me much. I wouldn't recommend doing what I did, but it really is your opportunity to get your foot in the door. So if you are able to get a training contract, definitely make the most out of it. And I would say, for moving to Silicon Valley, the fact that I worked so hard during my training contract definitely helped, because they ended up speaking to the heads of the departments in the tech team in London, and they recommended me to move as well. So that's my advice. I would say it's definitely a journey, and everyone's journey is different. But as I said, I didn't study law. I didn't have any contacts in the industry. So it's doable, and don't be afraid to reach out to people to ask for help as well. I had a lot of people that helped me along the way, and you know, meeting people in person as opposed to just writing an application form definitely goes a long way. And one trick actually that I did when I was applying, anyone I met at an open day, I would name drop them in my application form, because then HR went directly to that person to ask them about me. So that really helped me.
Great, thank you. Thanks very much. That was very useful. And Kweku, you were fortunate enough to, as you said, I think you had a pupillage by the time you were called to the bar. Like many others, it's a much longer and much more frustrating process. What advice would you give to prospective applicants? What advice would you give for getting many pillages and just generally throughout the application process up to qualification?
Yeah, well, look, there lies, damn lies, and statistics, right? And that is, we don't know if it was said by Churchill, Disraeli, but I'm still going to stick with the quotation. In terms of advice of what you do, I think it's pretty hackneyed in terms of the bar, mini pupillages, moot, etc., etc., etc. But if you don't mind, I think the approach people adopt to the bar, whether they're going to come to the bar and whether they are ready to come to the bar and what they have to do when they get to the bar in order to get a pupillage, can be informed by the statistics that the Bar Standards Board is desperately trying to gather and make them as important as possible, and also trying to feed into their program. And I think for this, the bar must get credit. Yes, the bar is not good enough at the moment in terms of where it is. It's not, we're just not seeing the results. And it's seen very much as an old profession. It's seen very much still as a traditional privileged profession, mostly a white profession. But things are changing, they're not changing quickly enough. It may surprise some students here to know that for the last 3 years, there have been more ethnic minorities called to the Bar of England and Wales than white people.
Wow.
Yes, wow. There have also been, in the last 3 years, more tenancies offered to women than men, okay? It's clear that there has to be a qualitative assessment, because as I said, there are lies, damn lies, and statistics, right? So there has to be a qualitative assessment. But if you just bear with me, what I just wanted those on this call, just to get a fair idea of what the statistics were. And those statistics were collected over 3 academic years, and invariably we're looking between 2015 and 2019 for some of the statistics, and for some of them they're even tighter than that. But in England and Wales, basically you've got 150 roughly thousand practicing solicitors, you've got about 16,000 practicing barristers, people with a practicing certificate, okay? So about 10% of practicing lawyers are barristers. In terms of the intake of students coming in and doing the bar training course, in 2019-2020, there were about 1,700 that came in. The vast majority of them are full-time, about 120 of them are doing it part-time. There has been a decrease in the number of students who are doing it part-time. That should say something to you in terms of what people are looking at in order to get and come to the bar. As I said to you earlier, more people have been called to the bar for the last 3 years. And in 2019 and 2020, there were 6,000 of those called to the bar. There were 601 ethnic minorities or people who identified as ethnic minorities, and there were 372 who identified as white. So it is quite a marked difference. And in 2019-2020, 35% of the students enrolled were from ethnic minorities. Now, this is where it gets interesting, because of course, we all know that there have been difficulties with even the whole category of ethnic minorities, BAME, et cetera, et cetera. So there is a lot more granularity needed, but I think there's some interesting points that come out and help to unravel the mystery as to why one ends up as a barrister. So you've got about, between those who were enrolled and graduated from the BPTC course between 2015 and 2019, 39.5% of them, and those are mostly the ones domiciled in the UK and the EU at the time, commenced pupillage. Okay, so 39.5% of people who spat out of that course over the course of 4 years commenced pupillage. Okay, and this is clearly down because we've seen that's as opposed to 49% in the previous year, and that shows that clearly there has been a reduction in pupillage. In terms of, I want to just deal with 3 more statistics, okay?
Sure.
The first is in terms of what determines your chances of success based on these statistics of getting a pupillage. We're not even dealing yet with tenancy. Well, let me say this to you. 2019-2020, dealing with those students domiciled in the EU and the UK made sense because, of course, they don't require work permits, and very few chambers, in fact, are going to assist you with a work permit, irrespective of what they say. But I do understand that there are moves in place at the Bar Council to try and change that, because, of course, we have lots of the bar courses rely enormously on fees coming from ethnic minorities, particularly those coming from Asia. So let's look at the education. In 2019-2020, okay, of those domiciled in the UK or EU, 31.5% of them had first-class degrees, 55% of them had 2-1s, 7% of them had 2-2s, and 3.5% of them had other classifications. Okay, so we're sticking with the domicile. In the same year, in terms of the bar practicing training course and the grade that you get, for many of you on this, I don't know if you know it, but there are essentially 4 grades. There is outstanding, there is then very competent, there's competent, and then there's fail. Well, that's my understanding. And of those students, 22% of them got outstanding grades, 70% of them got very competent, and 8% of them got competent. Now, how does that then tie in to the prospects of commencing a pupillage? Now, this is a statistic that I think is mysterious, and I look forward to anyone getting in touch with me and us trying to unravel the drop that you see in these statistics. I'm going to give them to you. So in the group as at March 2021, who had commenced pupillage and had been graduates from the bar course between 2015 and 2019, okay? If you got an outstanding grade in the bar course and you had a first-class degree, okay, 75% of those people with a first-class degree and an outstanding got pupillage over the course of the 4 years, okay? If you had a 2-1 and an outstanding, 70% of them with a 2-1 and outstanding got commenced pupillage in those 4 years. If you go down to very competent, and again, of those who, 70% of people get very competent in 2019-2020, but that gives you a general idea, because now when we're looking at a cross-section of 4 years, when you get down to very competent, of those who had very competent in the first, under 50% of them start pupillage. Of those who have very competent and a 2-1, only 36% of them had pupillage, commenced pupillage within that 4-year block. Of those who had a 2-2 and are very competent, 20%. And then we go down to competent. If you have a first class and a competent, those with first class and competence, 20% of those started pupillage, 2-1 with a competent, 8%, and 2-2 with a competent, 11%. Final statistic for you, which is, I think, incredible and goes to show what you need to have in mind as being the statistics that meet you, which certainly doesn't mean you can't get past the statistics, because there are, of course, outliers. And my approach has always been, if there is someone in there who I can compare to, don't care what it is. If you happen to have a 2-1 or a 2-2 out there and you're saying to yourself, God, I can't come to the bar. If there's someone out there who's got a 2-2 and has got to the bar, my approach is I can do it because they're still accepting people doing it. So I'm not dissuading people by these statistics. That's all they are. But let me tell you this. The statistics have found that not only your grade at bar school is important, that appears to be the most important from the statistics I gave you, but also your university degree, but also where you went to university. And I want to end on this part of where you went to the university. Some of you may or may not know that every year the Times publishes its top universities in England and Wales, in Britain, in fact, because it includes the universities in Ireland. And there is one statistic that goes to show, in my view, that where you went to university matters more than the grade you got at university. Okay, where you went to university matters more than the grade you got at university in terms of commencing pupillage. And that is this statistic, that 52.5% of those who had a 2-1 and are very competent from a top 10 university in the Good Times University list got commenced pupillage. 52% of those with a 2-1 from a top 10 university by the Times commenced pupillage by the 31st of March 2021. That compared to 44% of those with a very competent and a first-class degree from a university that was outside the top 10, but in the next 11 to 50 universities. Okay, so that goes to show you that there still, it seems from this statistic, or it is something you may choose to draw away from this statistic and look into it further, but it still appears to be the case that where you go to university matters. Yeah. And I think that is one of the issues that the chambers and the Bar Standards Board seeks to deal with. I don't know quite how they're going to deal with it, but it's certainly a statistic that anyone wishing to come to the bar needs to know about. So, quick roundup: get as best a grade you can at bar school, because actually it does matter, and it seems to matter perhaps more than your degree. And then follow on with, because of course at that stage you can't change, but if you can change, and it's a question of, look, I want to come to the bar. What university am I going to? This university has a really great course, love it. This university has a really great course, love it. Actually, on this particular statistic, it seems to me that the choice you ought to be making, if you've got the bar in your mind, is to say, actually, which is a better university? Sorry, thanks. I digressed, but I think those are important statistics for people to know.
Thank you. No, I think that was it was very interesting, and I think it's important just interpreting those statistics as to what appears to be the most important factor. I think the overall message for those of you who are in attendance that are considering qualifying at the bar is just do as best as you can at the particular stage you're at, because of course if you're 2 years into a 3-year degree, you're not going to be able to change which university you go to. But as Kweku explained, if you go to the bar school and you get an outstanding, then you're very likely, just based on the statistics, to get a pupillage. So just do the best that you can, I think, from whatever position you're currently in, and I'm sure.
And can I just add that those statistics in terms of university degrees, they've only looked at your first university degree.
Okay, so not
so that's
masters.
an important distinction as well.
Brilliant, thank you very much. I'm conscious that we're coming to the end. I just want to ask one more question of the panelists. But if I can ask that you limit your responses to 30 seconds, so we have a bit of time to get some questions in. So what's one piece of advice, I think we may have covered this very briefly, but just to summarize, what's one piece of advice you would give to someone who might be interested in pursuing your career? In particular, if you could focus on what would be useful to know at the application stage, just one piece of advice. Caroline, you go first. I know you've covered this already, but just in a nutshell, what would you say?
Sure. So just to reiterate, and I think Kweku mentioned this as well, really know what you're bringing to the table and know what your story is as well, and how all the different experiences that you've had tied together and how you can apply them to the legal field. There are some things that you may not think are as important, but you can definitely always add to your character. So even if you speak a different language, so for instance, I would, tell people I grew up in Italy, I was born there, I speak Italian. Things like that really help you to stand out in the midst of other candidates. So definitely know your story and go to as many open days as you can.
Brilliant. Thank you very much, Caroline. And Desiree?
Yeah, I think that was great advice, actually. I think you should know your value. Like you, I was actually born in Austria, so I speak German. I definitely use my German skills. So definitely any skills that you have, you should sell. You should be able to sell yourself during the interview and believe that you can do it as well, and be always willing to learn. Because what I've noticed about my role, you will never stop learning. You should always be willing to learn, keep an open mind, be adaptable, be flexible, and yeah, just keep it going.
Brilliant. Thank you very much, Desiree. And Kweku?
2 points. Don't pull yourself down. There are lots of chancers at the bar who are barristers, and the reason why they get in and you don't get in is because they have not pulled themselves down. Second point, which marries exactly what the other panelists have said. Why you? Why on earth, with a 2-1 and very competent, should we choose you over someone else who's got a 2-1 and very competent? And that is your unique selling point. Try and find it. I know this talk is about pathways to a career, but when you are applying to come to the bar, you kind of have to be a conclusion. You need to know a bit more about yourself. You need to know that you're determined, what kind of characteristics you have, because boy, it's a long run.
Yeah, great. Thank you very much, Craig. That's very helpful. I'll just go through some of the questions in the last 5 minutes. The first one is for you, Kweku, although I'm not sure if you'll know the answer, but the question is, could you please ask Kweku what the name of the course that he undertook for 3 months was for the qualification process in Ghana, and what the name of the qualification was?
Right, so it's a post-call course, because you can only get onto it in Ghana if you'd been in a common law jurisdiction and you had been called, either enrolled on the roll of solicitors in the UK or wherever, Canada, wherever you were, or called to the bar. At the time, it was a 3-month course. I understand it's increased, and now it's about 9 months. And I think it's a course that's very worthwhile, and it certainly adds to your CV.
Brilliant.
So that's, of course, it's a post-call course in Ghana, offered by the Ghana School of Law in Accra. Great.
Thanks very much. And Desiree, next one to you. Do you need any certifications to enter into the AML KYC field?
No, I don't think you need any certifications. I think anyone can do. I do believe though that a law degree will make you stand out, and I think it will be very beneficial to have a law degree. But you don't need any qualifications per se to get an entry-level role. However, I do believe that if you want to have something a bit more senior, it would be recommended to have a certificate.
Sure. Thank you very much. And Caroline, I've got this from quite a few people now. I think you may have covered it twice now, but just anything Latham specific. How did you get your TC at Latham? Is there anything in particular that someone who wants to apply to your firm in particular should know? Any quirks about the application process or anything else that you might advise them?
Sure. So as I mentioned before, I'll definitely recommend applying for the vacation scheme first of all, and not applying directly for the training contract like I did, as that will give you more of an opportunity to make a good impression. And they also hire primarily from the VAC schemers. Aside from that, I would say go to the open days. We usually have open days during the years. I'm not really sure what's happening with COVID at the moment, but that's another opportunity for you to meet lawyers there. And as I said, if you're able to meet any associates at those events, definitely mention it in your application, as the graduate recruitment team often does follow up with anyone that you name drop. Definitely show an interest in the industry, show how your experience in university has developed that interest. And Latham generally likes to hire people who are very proactive, have a positive attitude. So if you can have a list of examples of when you were able to show those skills, that will help you to get ahead as well.
Brilliant. And Kweku, there's a question here, which I think I know the answer to, but I'll defer to you as my learned friend. Is there a time limit to the pupillage?
In terms of, is there a time limit after passing the bar course before you have to take?
It doesn't say, but I presume so.
Yeah, I think there is. I don't know what that time limit is, but I also do know that that time limit can get refreshed if you apply to the Bar Standards Board and you have some sort of reason or dispensation. Remember, I mean, the Bar Standards Board, for example, you have a disability, they have to make reasonable adjustments. So it very much depends on your circumstances. But I off the top of my head, I seem to think it's something like, it might be some up to 5 years or something like that.
Yeah, it looks like, I think Tokes has very helpfully put that into the comment box. I think that's right. Desiree, I have another question for you, which I think will be our final question. So obviously, all professional firms will have compliance departments, internal AML checking capabilities, because of course it's a legal requirement. You said you work in fintech. How did you identify that particular industry? Because you can work in compliance in a law firm. I have a lot of experience with compliance in my firm, and I can tell experience that meticulous. So how did you identify fintech as an industry as opposed to any other industry which might require compliance or AML officers?
So what I would recommend is trying to work in different industries. That's what I did very early in my career. I've done a lot of contracting. Even if it's just for a few months, it's just to get like an idea of the industry, to see if you like the climate, So I have worked for investment manager, I've worked for third-party administrators. I've heard a lot about FCA, how that kind of working environment is as well. And fintech was just perfect for me. It's quite a more flexible, relaxed type of environment. I feel like it's very suited to my personality as well. And literally my colleagues are so smart as well, but they're very relaxed, very cool, they're like very relaxed, and I love that. And so I would definitely recommend to do a bit of contracting, work around, try to, get a feel of different industries and stuff and see what you like. It might be that you love investment management and you're like, yes, I love tight regulations, or you might want something like fintech where it's a bit more relaxed, but you still have to, comply with regulations, but it's just the culture is a bit more, relaxed.
For sure. Thank you very much. And with that, I think unfortunately we're out of time, but I'd just first of all like to thank our wonderful panelists. I think from the comments, I think everyone really appreciates all of the advice that you all gave. So thank you very much. And thank you also to the attendees, especially those who've been here since 6 o'clock. Thanks for giving up your evening, and I hope you've found the two presentations useful and insightful. So as I said, we're going to put this video and the previous video up on our YouTube channel and I think on LinkedIn as well. So if you want to go back and review anything, then you'll find the link on there. But thank you very much, our panelists, and thank you to the attendees, and hope everyone has a good evening. Thank you. Bye now.